I think that if we all start from this viewpoint that HIPAA was never written with the intention to be a blockade, the concept that it's now being overly broadly applied in settings where it was never meant to apply is your first line of defense. I'm relying on the language here that says HIPAA helps by allowing mental health providers to make decisions about communicating with the family based on professional judgment about what's best for the patient.
In trying to help a loved one, have you ever felt that HIPAA is more of a moat or a blockade than a bridge? Our guest on this episode, Laura Brancato, has information and tools you can use if HIPAA is getting in the way. Part of her vast knowledge of understanding the laws of mental health, and we can too. Welcome to our podcast, Schizophrenia, 3 Moms in the Trenches. From the place where schizophrenia and real life collide. East Coast, West Coast, Middle America. With Miriam Feldman, Mindy Greiling, and Randy Kay. Finally, a place to talk about the truth. Well, welcome to an episode that we have been wanting to do for a long time. And when I was in South Carolina for a neuropsychiatric conference, I met the perfect attorney to help us. We're so excited. If you're new to the podcast, this is Schizophrenia, 3 Moms in the Trenches. It's pretty much what we are. We're 3 moms with 3 sons. Not 3 each. We each have 1 son. Our sons have let's not make it too crazy. Our sons have schizophrenia, and we're in various stages of recovery in the roller coaster that is. And this podcast is to share experiences, to share stories, and we love to share information. Some of our most listened to episodes are explaining things like Social Security and guardianship and conservatorship and what to do in a crisis. And tonight, we're going to dive right into it for you. When I was at the neuropsychiatry conference, and we will have Dr. Rocky on the show very soon to tell us more about that. I was able to present, but also hear some amazing presentations. And when I heard our guest present, I was like, we got to have her on the podcast. I have been dealing with schizophrenia in my son, Ben, for 2 decades, and I learned more about HIPAA that presentation than I've known. So let me dive right in to introduce our guest. Our guest is Laura M. Brancato. And with your permission, Laura, I'm going to read what you wrote as your mission on your LinkedIn profile.
Sure.
And it says, as an attorney and an advocate, my mission is to provide specialized legal advice and support to families with vulnerable loved ones. Raise your hand if that's you. Okay. With a focus on mental health, special needs, elder law, substance abuse disorders, and related matters, I'm dedicated to helping clients navigate complex legal landscapes and achieve the best possible outcomes for their families. I believe that everyone deserves access to compassionate, informed, and effective legal representation. So we are already super fans. Welcome to the show, Laura.
Thank you. So really happy to be here, Randy, and nice to meet everybody. And I'm happy to share whatever knowledge I can to help make this journey a little bit less frustrating for everybody involved.
I'm just going to add here, this is probably the most asked question. You know, we all of us, because of our books and our profiles in the country, hear from a lot of families. And this is what I'm asked about the most. Just even today, I was talking to a mother from Indiana, and she had a multitude of problems and issues, but this was number 1. So this is timely always. I bet this will end up being a hugely popular episode.
Yes, I absolutely think so. So before we hand the show over to you, which is what we're essentially going to do, you're going to share your screen. Now, if you are watching on YouTube, you'll get to see the slides. If you are not watching on YouTube, you'll hear Laura speak about it. The audio will suffice, but you can always go to YouTube and check it out as well. But can we first ask you about your story a bit? Like,
Sure.
what law is a huge practice? I know you were a district attorney in the Bronx, and you're from Queens, like I am. Yay!
Yep.
And but now you're choosing this. So, is there a story behind that?
Sure, of course. So I started my career in the district attorney's office, as you mentioned, Randy, in the Bronx, which is a really unique community of what I would deem vulnerable people for a variety of reasons. And I really relished my time there. I spent a lot of time in the treatment court parts, in the mental health parts, in the elder law unit, the gang unit, other places where I just saw different legal processes and how they affect vulnerable clients and vulnerable defendants and individuals. And so when I left that work, I transitioned into civil practice, primarily working with elderly individuals in guardianships and other cognitive impairment spaces, traumatic brain injury, things like that. And then my first child was born. And without any notice, we discovered at 8 months old that he has a genetic abnormality that kind of puts him on a different life track. And
Mhm.
lovely, lovely 13-year-old boy, but certainly will have his challenges, has his challenges, and will in the future. And for many kids with his syndrome, schizophrenia is more likely than not in potentially in the future. And so it kind of spurred my interest in special needs practice. And the longer I did that, the more I realized just how underserved clients who have underlying mental health conditions really are. And I would hear more and more from families that they were told by attorneys that there was nothing that could be done, there was no advocacy that could be had for them. And the more I looked into it, I realized that that actually wasn't true. And I've spent the entirety of my 22-year career in the courtroom. And I've been using the legal process in lots of different ways from, 2003 to current time in to really get better results for families. And so it's been kind of a journey over the last 6 years, I would say, to really understand and better immerse myself in substance abuse and misuse disorders. We do some work with eating disorders, gambling addiction, really anybody who suffers from a atypical profile in some ways. And of course, there's comorbidity with substance abuse or misuse disorders. And then, of course, the interplay with lots of different criminal processes, lots of different civil processes, family court, orders of protection, really all of the different ways that people come into contact with the court came up during the practice of this in this specialty. And so I decided to really focus on those areas rather than just staying as an elder law practitioner or working only in special needs, just to be able to say that the issues that people face if they're vulnerable are really one and the same. And how can we make sure that we get as much advocacy for kids with a mental health diagnosis as we do for kids on the autism spectrum, as we do for elderly people with dementia or Alzheimer's? Because ultimately, from a legal perspective, I see all of those people as the same. They come to the world with deficiencies or inefficiencies in their profiles that need to be supported regardless of what's driving those outcomes. And unfortunately, I find that the legal system as it pertains specifically to people with serious mental health issues just isn't properly applied, and families get the wrong advice or get pushed off much more easily. And society allows that to happen as well. It's kind of a full circle societal issue. And so I really started honing in on being a much stronger advocate for my clients in that space. And so it's from a personal perspective, of course, because maybe one day I'll be having this conversation from a different vantage point. But for now, of course, I still have a very vulnerable teenager in my home, and I look at what I would want his outcome to be, and also just to have the law apply evenly to everybody, to have this fair standard, to everybody starting on the same level playing ground, and making sure that we use advocacy to enforce the laws as they're written, not as somebody wants to interpret them to be, which is really one of the things we'll talk about a lot with HIPAA today.
All right. So, I did notice you also have a video available on the Silver Hill website that isn't as specific as what we're talking about tonight. But what caught my attention on that is that you mentioned how so many judges don't stay in this field. They have a shelf life of about a year, and then it's too complicated and they go on to matrimonial law or other things. So you spend a lot of your time educating judges how to
Yeah.
do their job well. So I think we have the perfect guest. I'm going to turn it over to you and have
Great.
you share your screen, and we three moms will pop in with questions
Of
as they
course.
come up, but I think we're going to let you present what you've got.
Sure.
So
Sure.
thank you so much.
Of
Education
course.
is gives us as much power as we can get. That's what I think.
100%. I think that the way I approach my private client work, and I say private client work because I do a lot of work as appointed by the court, which we'll talk about a little bit tonight, but is to really just arm people with a body of information that they can use in different circumstances. Because it's not just the judges who lack information. I'm sure many families who've cycled through hospitalizations know that even the social workers are often uninformed or new, or they themselves are in and out of, a mental health setting. They may be one day in a general medicine floor, the next day they're on a psych floor. They don't have specialized knowledge. And so we're really all hoping for the same outcome. And so if we're all working from the same baseline of information, I think we have a much better chance at getting it right.
All
So,
right. Go
we're
ahead.
calling this here Understanding the Laws of Mental Health. And I want to just start by saying that we're going to look at this from the perspective of a lot of different legal concepts, and HIPAA is one of them. But I want to touch quickly on some of the other legal processes because they all intertwine with the concept of HIPAA. So when I say here reactive legal concepts, what I mean is that we're talking about something is already going on. Somebody's behaviors are already unhealthy or unstable. They maybe already are in touch with the court system in some way, whether it's a criminal or civil case. Maybe they're already off their medication or not abiding by treatment protocols or recommended treatment plans. And so reactive legal concepts are where we find, I would say, 90% of the time, unfortunately. I would love to be counseling clients in a proactive legal world, but more often than not, I'm getting the phone call when something is already not working well and we're reacting to whatever is going on in the moment. So the most common question I get, of course, is about whether guardianship or conservatorship is going to be effective. That could definitely be a conversation. I'm sure you've had it on this podcast of its own. But generally, in the mental health world, especially in New York, guardianship and conservatorship, Connecticut, are not super effective for people suffering from serious mental illness for a variety of reasons. But it seems to be the knee-jerk reaction. It doesn't often play out very well. It's very expensive and time-consuming. And of course, it's adversarial. So you as a parent or a loved one are making yourself an adversary to your child or your spouse or your sibling. And that in and of itself makes the dynamic complicated. So, that's not necessarily the preferred mechanism. We can talk about things like treatment over objection, medication over objection, which are obviously emergency measures when a person is not, well, or they're potentially harmful to themselves or other people, and a hospital or other setting is seeking to have them treated or medicated over their objection or without their consent. And we'll see HIPAA interact in that way in many different concepts. But of course, whenever a loved one is hospitalized, if they haven't signed that release of information, you may be battling a hospitalization where they're being treated and you have no concept of what's going on. And usually the sword that's used by the medical facility is HIPAA. I can't disclose anything because of HIPAA. And we'll talk about if that's a real prohibition or not. Assisted outpatient treatment is the outpatient version of supervised medication. I mean, most states have it at this point, and it can be very effective, utilized with other tools to support someone in the community. We also see HIPAA intersect here because, if a patient is under an AOT order, those proceedings are private and sealed unless they give you access. You can't get it. And often the response is because of HIPAA, I can't disclose. So you may not even know what the protocol is or what the medications are that are being prescribed. And so, really, what I'm aiming for is the best outcomes for my clients come when we can create a very broad circle of support. But how do you create a broad circle of support if the support people are not allowed to participate in the discussion? And the person at the center of the discussion is coming to the conversation with unrealistic ideas, unrealistic goals, maybe even delusional beliefs about what will or will not happen. Maybe they lack financial resources and they're making a plan based on the goodwill of other people. And so we're always talking about how can we have a really well-informed circle of support. And we'll skip HIPAA for a second. And the criminal law concepts, HIPAA also kind of intersects here. If a person is arrested for committing a penal law violation in New York or other states, there are HIPAA implications to the cases that they are involved in, especially if it comes down to using a psychiatric defense. The person wants to, assert a psychiatric defense. There's all kinds of prohibitions on whether that can be shared and how it can be shared, which can make it difficult for family members or parents to really support through that process. And so the way I think of HIPAA is it's used as a blockade, right? I think of it as something like a wall, a way that a medical facility or a provider creates distance between themselves and the patient and everybody else who's seeking to either have input, provide information, receive information, or create reasonable support plans. And so it caused me to really do a more of a deep dive because it seems to me that HIPAA um, that there's this concept involved in HIPAA that a person who refuses to permit information to be released to family, that they somehow are doing that with an informed mindset. And one of the most important concepts in all of these legal proceedings on the screen, guardianship, treatment over objection, AOT, criminal law, is the law presumes in all of those circumstances that the person's mindset is not functional. And so it permits other people to make decisions, like a medical facility, like a judge in a conservatorship, like a judge in a criminal law case. And so why is it that when we get to HIPAA, which is the most important part of the outpatient treatment plan, we suddenly assume a person in the throes of a psychiatric emergency has competency, legal competency, to assert that they don't want information shared? So
I
there's this division
absolutely
here.
love the way you put that. I think that is brilliant. Let me ask a question here. So you mentioned at the beginning, and that was music to my ears too, that the courts don't treat people with serious mental illnesses as well as other people with neurological brain issues. And so that was a statement right there. When you get to this problem that you're now talking about, is this also more pronounced for people with serious mental illnesses? Do they assume that people with autism can make all their decisions and never mind and so forth, or is it just mental illness?
We have seen, Mindy, that when the illness is originating from anything other than a mental health impairment, that we will often have very cooperative or collaborative providers, people who are approaching it compassionately. You never hear, I have never heard in 22 years of medical provider say, this individual with Down syndrome might sue me if I give you this discharge treatment plan, right? We don't approach people with dementia and say, well, Mrs. Smith, tomorrow, if I let you in on whatever her neurological disability is at this point, is somehow going to sue me. The law doesn't see her the same. The statutes don't treat her the same. We actually, in our guardianship law in New York, there's a carve out. The standard in New York is functional inability. If a person fails to function, they likely need a guardian in New York, except in the psychiatric world, where there is this carve out where we say in the guardianship statute, which is why it's not effective in New York, unless your deficit is coming from a serious mental illness, at which point we throw you into another legal proceeding where you have all these constitutional rights to keep making choices for yourself. And it's very illogical to me, and I often say this when I'm arguing these cases in court. If I didn't tell you what the origin of the dysfunction is, if I just told you what the functional inabilities were, and I did not say where they were derived from, you would give a guardian every time. It's only when you hear me say that this person who can't feed themselves, can't keep a clean or safe home, doesn't take their medication, doesn't visit the doctor, creates hazardous conditions for other tenants. That could be an elderly person who's suffering from a cognitive problem. But as soon as I tell you that's a person with schizophrenia, all of a sudden we can't appoint a guardian, right? So it's a very bizarre niche in the law, and it really stems from these very well entrenched concepts of right to bodily freedom. constitutional rights to bodily freedom.
Yeah, absolutely. I think, we're all nodding our heads here. We couldn't agree more. And for our listeners, just so you know, we do have other episodes you can look up. I'll put the numbers in the show notes about conservatorship and guardianship and Social Security and applying. We have other episodes about that. But I do want to say that I so completely agree that conservatorship has been my way around HIPAA for 20 years with my son. However, it did get in the way of our relationship. And so it wasn't expensive to set it up. It was time consuming. It wasn't my expense to set it up when he was hospitalized. But right now, I am very grateful to have given over his conservatorship to an attorney who does that work. And we are co-conservators of his person. But not being in charge of my son's money from Social Security anymore has been a game changer for our relationship. So I totally applaud that. Okay, thank you. So
Sure.
HIPAA, let's.
Okay, here we go. So, well, these are slides. I'll just keep them up for a second. So if people are going through it, but this is what we're looking at from a guardianship conservatorship standpoint. And as you said, Randy, one of the most important things that you can get, even in a New York guardianship, might be access to treatment records and or the ability to participate in discharge planning discussions. Some judges will allow that to happen, others will not. And it just depends on where you are, what county you're in, and how proactive the resources are in that county. But for sure, what we're talking about here is you just want to be a member of the conversation. It reminds me very much for those of us who've ever had children with IEPs. When you sit in an IEP meeting, the school district often tells you you're the most important member of the team, right? You're a member of the team because we know when the school day ends or when everybody else goes home for the summer, that child is sitting in your living room. And how can we help you to support them and make sure that they're reaching their highest levels of achievement? And somehow, when you turn 18, even if you're still not functioning very well, all of that disappears because in every state in this country, when you reach the age of majority, which is 18, you are an emancipated adult, whether you are functioning or completely nonverbal and completely dependent on some other person, you are under the law an emancipated person. And so all of the constitutional rights, the Bill of Rights, all of these the Fourth Amendment rights to bodily freedom automatically apply to you, even if you are not self-sustaining. So same would apply here. Okay, so it's important to understand at the outset that HIPAA is an enormous piece of legislation. The HIPAA that we think of when we talk about the, release of health protected information, or here we call it PHI, protected health information, is a minuscule part of a huge statute. And the statute dates back to 1996, and it was a federal law that was introduced at the time when medical records were becoming electronic. There were more data breaches, people's information was able to be accessed, and this was set up as a way of protecting people's private or PHI information in, let's say, a server at New York Presbyterian Hospital, right? This was meant to create safeguards to prevent the unauthorized access to sensitive information. This bill is enormous. There are 5 sections known as titles, and the titles relate to all different kinds of things, as you see here. Health insurance reform, which was only relevant back in the 90s when this was all happening. Administrative simplification, which we'll get back to in a minute. Tax-related provisions, which had to do with how medical institutions deal with tax implications of different parts of administrating the medical record system in the hospital. Enforcement of group health plan requirements and revenue offsets. So this was meant to address lots of different problems that were going on. This had to do with, if you look at the title, health insurance portability. The main issue that was being tackled at the time that HIPAA was being, when this law was written, was that people be able to have portable health insurance. This had nothing to do with preventing the release, for the most part, of sensitive information as it pertains to an individual. And when we look at the next slide about which HIPAA violations are most frequently reported, as you can imagine, especially today, the most frequent breaches that are reported are outsiders breaching or accessing systems that are not properly set up by healthcare providers, by doctors' offices, by your mental health provider, and where your records could be accessed by a stranger or stolen for purposes of getting your credit card information, let's say, right? So the vast majority of HIPAA violations, and I would say almost all of them, have nothing to do with the individual release of information about Mr. Smith. It has very little to do with that. So I think that if we all start from this viewpoint that HIPAA was never written with the intention to be a blockade, that it was an enormous piece of legislation, as most federal legislation is, that was meant to address a multitude of titles or sections, and that administrative simplification is one of those five places, and that's where we find the rules about release of information. So the two main purposes of the bill to provide continuous healthcare coverage for workers who lose or change jobs, and to ultimately reduce the cost of healthcare by standardizing electronic and administrative financial transactions. That's in the language of the how the bill was introduced. So the concept that it's now being overly broadly applied in settings where it was never meant to apply is your first line of defense, which is to first understand if anybody is ever using HIPAA as a preventative measure, on whose basis are they raising the objection, right? So Title II, which is administrative simplification, is where we see HIPAA compliance. So every medical institution that we know of or that we interact with has to abide by the HIPAA compliance rules, which is why when you do, let's say, a telehealth visit, you have to click in 10 different ways and say, you agree to be on this screen. They have to give you a certain software. Those are all HIPAA compliance mechanisms to make sure that nobody is spying on your medical appointments, to keep your privacy. None of those provisions have to do with somebody asserting HIPAA on your behalf. And so one of the biggest problems that we see in this space is a medical provider asserting HIPAA on behalf of a patient who may or may not be capable of even understanding that HIPAA is being asserted on their behalf. Because I would argue most of the time, the person over whom the person who relates to the information isn't capable of forming any legal intent about anything, and therefore can't really be asserting a refusal to have that information shared. So I think that whenever I'm advocating with a client who's, let's say, a loved one's in the hospital and we're just trying to be a person in the room. I was thinking Hamilton, I was watching the Tony Awards the other night, and that song, I want to be in the room where it happens, right? I just want to be in the room where it happens because I want to bring reality to what might be a very unrealistic discharge planning meeting. I need to be in the room where it happens so that you can all understand I am not bringing my son home. I am not paying for him to live here. I am not going to allow him to, refuse to go into an intensive outpatient treatment program. None of the things that are being relayed in this meeting are accurate, and therefore you can't go forward with this discharge, right? So I think that's the best part to, from an overview perspective.
Before you go on with
Yeah.
an overview perspective, maybe if you're talking about it later, I can wait. But do you know the status of the legislative proposals to change this and update it and make it clear that families should be involved?
I don't know the status of any of the proposals, but I do know that they come up almost on an annual basis. And they're often met with as you can imagine, very strong opposition from hospital systems and other providers. One of the biggest changes that we've seen over time is that as healthcare becomes more frequently and broadly owned by private equity firms, by hedge funds, by private investors, that we're seeing that the privatization of even what used to be, let's say, not-for-profit nursing homes, which are now for-profit endeavors owned by big companies, that the problem is getting worse and not better. Because of course, they want to simplify and make efficient every single process. And so being able to say that, if a patient will not sign that release of information document, we are not going forward with talking with you. That's a very easy black line, right? And so nobody wants to get into a more genuine discussion about whether or not the person can actually assert that right. And that's where advocacy and your consistent advocacy is going to be important.
That's so sad, so sad.
Oh.
Saving money by shutting out the families with the HIPAA sword, as you called it, so
Right,
aptly named.
right. So one of the things that I would love everybody to take some time to look at when you have a chance. So HIPAA is administered by, as you see up here in the right-hand corner, the U.S. Department of Health and Human Services. And when you go to the Department of Health and Human Services website, you will find everything relating to HIPAA. And one of the things that I find very interesting about the website is that they give a lot of practical information to families, right? And one of the links that you find when you get to the HIPAA section are a lot of different links with similar titles to this. HIPAA helps caregiving connections, right? So you read this and you think, wow, like HIPAA's really here to help me. Read this title. HIPAA helps friends and families stay connected with loved ones who have a substance use disorder, including opioid abuse or a mental or behavioral health condition. Now, I
Ha!
guarantee you that no one on this call or listening to this podcast would say, HIPAA is my friend. When I think of HIPAA, I think of caregiver connections, right? But if you go to their website, you will find article after article written just like this that talk about how HIPAA is supposed to be a bridge from the patient to the caregiver, and that the medical institution in the middle is supposed to help make that connection. And so, what I often do when I'm advocating for a client is I print this out. And when I write my letter to the medical institution saying, you can't use HIPAA in this way, and we'll talk a little bit more about what that looks like in a minute, I often include these bullets, these letters, and there are many. Some of them deal specifically with serious mental illness, others deal specifically with substance use disorder. And when you go on the website, they have this, link and it says like, if you have a question about this, click here. A question, it's a very user-friendly scenario, but if you read this, you would think that this is a walk in the park. If a family member, friend, or person you are caring for has a mental health condition, substance use disorder, or other health problem, it can be difficult to stay connected if their condition worsens and they enter a healthcare facility for observation or treatment. HIPAA helps by allowing the health and mental health providers who treat your loved one to make decisions about communicating with his or her family based on their professional judgment about what is best for the patient.
Oh my God. See, this is game changing.
Right.
This is so game changing because I don't know any family. I don't know, Mimi, did you ever have anything, it I don't know any family that they could, yes, HIPAA is a bridge from us to you. Wow.
No.
Yeah, and I actually knew this. I just told this advice to this mother from Indiana, but no one, why does no one else know it? Like the ones who are using it wrong, like the
HIPAA is
professionals.
a moat. It's not a
Right.
bridge.
Right.
It's
It's
a
a
moat
ditch. Yeah.
around the
Right.
hospitals and the doctors that keeps us from them. And
So I
then
think, yeah, and I think that the main reason that this isn't used more frequently is it's time consuming. It is time consuming to sit and let a discharge plan develop over time, right? If we're looking at this in the most frequent way that I communicate here in this space is about discharge planning. We'll take this example. I had a client last week who has been hospitalized for about 4.5 weeks, probably needs to be there for another 4.5 weeks, but we all know that's not going to happen. And so we're already in this discharge planning phase. The patient is asserting nobody's allowed to communicate about my discharge plan. I don't want anybody else involved. And so I continue to advocate for the family, writing lots of letters, sending lots of notices like this. And I say, at the very least, tell us what the discharge plan is. Give us the proposed discharge plan, even if we're not allowed to sit in the meeting. And then I'm going to comment on your discharge plan because I'm relying on the language here that says HIPAA helps by allowing mental health providers to make decisions about communicating with the family based on professional judgment about what's best for the patient. So then they will send me, most times they will, the discharge plan. And I will write back with red letters all over it saying, this is not going to happen. This is not going to happen. He's not allowed to come back here. There's an order of protection. All the things the patient either didn't share or won't share or doesn't even realize exist that will prohibit them from carrying out the discharge plan. And I've been very successful in then turning this language around and saying, and this is a really important line for families to stick to, and I know this is exceptionally hard. If your child or your loved one is over 18 years old, you are not responsible for being the discharge plan. The hospital cannot make you be the person who receives somebody out of inpatient treatment to your home or with your support, financial or otherwise. And so, what I do is I flip this around and say, you have not identified a safe or appropriate discharge. Your proposed discharge is neither safe nor appropriate, and I would argue it's completely unavailable. And I'm putting you on notice that if you discharge this person with this plan, you are in violation of the Medicare laws, which they would be, that you have to have a safe and appropriate discharge. And so then I will use these types of memos to say, why don't you let us participate in the conversation so we can all come up with a safe and appropriate discharge, which is what you want and what we want, because they want the person out and we want the person safe, but we can't pretend that there is some support mechanism that isn't there. So if you look down here, it says for notification purposes, HIPAA helps you stay connected with your loved one by permitting health professionals to contact you with information relating to your family member that is necessary and relative to your involvement with the patient's healthcare or payment for care. So I will highlight that language and say, I know you always allow me to give you information, but this document from the federal government is telling you, you can also tell me information that's relevant to the patient's healthcare or payment for care, which is another weird void. You're somehow responsible for the payment, but you're not allowed to know what you're paying for. It's bizarre, and it doesn't comport with the way the law is written. And it even says right here, for example, if your loved one becomes disoriented, delirious, or is unaware of their surroundings, due, for example, to opioid abuse or a mental health crisis, and arrives at a hospital emergency room for treatment, the doctors, nurses, and social workers may notify you of the location and general condition. The staff will determine whether the patient agrees to share information with you. If the patient is not able to make decisions, for example, due to being unconscious, sedated, intoxicated, or disoriented, then doctors and nurses may contact you without the permission when they determine doing so is in the patient's best interest. So I will often rely there and say, I don't think John Smith has the ability to make these decisions because he thinks that the Messiah is coming tomorrow, and that's why he's building a bomb shelter in his basement. And so I want you to release this information to me because he's disoriented and can't legally consent, can't legally assert protections.
Wow. So this covers not only discharge, but also many, many families who say they won't even tell me if he's in the hospital. And we've been in family to family sometimes who say, well, you can get around that. Say, if he were in your hospital, what room would he be in? Like trying to get around what they think HIPAA is, but that isn't what HIPAA is. This is the website is Health and Human Services, U.S. Health and Human Services, and this little flyer is available for anybody to print out.
Anybody.
Anybody.
How many attorneys are there like you, Laura? You know, in Minnesota, we get an attorney if we're going through civil commitment. Both sides
Right.
get an attorney. If we're going through guardianship, both sides get an attorney. They're
Yes.
free for both sides.
Oh, wow.
By the way,
Yeah.
my family did not get guardianship like Randy's did. And also we have one other layer in our state where they don't want to appoint the parent. They appoint someone else. And then you're one more person away from knowing
Removed, yeah.
anything.
Yeah.
But why, it seems to me, if we're going to not reform HIPAA, we all should get an attorney like you. How do people find you? And are there attorneys like you all over the country or just in New York?
So I don't think we're just in New York. There are a handful that I can think of in New York. There aren't many. Sometimes if you start with resources like NAMI. NAMI usually has in each state, they will have, the National Association for Mental Illness on their website or in their support groups, they will have a list of lawyers that handle these kinds of cases. Sometimes you can get assistance from mental hygiene legal services or state-run legal assistance groups like Legal Aid. Sometimes will have attorneys with a specialty. I find that my colleagues who are elder law attorneys, who we go under this title of elder law, even though now we're really dealing with incapacity at every age, They also have specialized knowledge because HIPAA, you can imagine, kind of creeps into a lot of these places
Mm.
with vulnerable individuals or people with cognitive deficit. And whether that's because of Down syndrome, autism, or cerebral palsy, or if it's because of dementia or traumatic brain injury or a serious mental illness, the as I said at the beginning, the issues are the same. And so oftentimes lawyers can kind of get you far enough along in the proceeding. But this information about HIPAA is not something that I never learned any of this in law school, right? I'm very removed from law school, but I've been practicing in these civil spaces now for well over 15 years. And these are just things that I've figured out by myself, by really asking the questions about when somebody asserts something as being true, actually going to the law and reading it to say, is that actually true? And unfortunately, 50% of the time in the serious mental illness space, it's not true at all, right? And we're really battling stigmas in the mental health system, in the medical system. We're battling societal stigma. We're battling a chronic lack of resources. And this is not an easy space to practice, as you can imagine. So we don't get a whole lot of attorneys who are knocking at the door to do this work because it can be very frustrating. And,
Right. And
you know,
I've been on not Minnesota's NAMI state board. I've been on the national board. I'm recent president of my NAMI affiliate.
oh
And I
wow.
have called NAMI for attorneys for other things, but I did not know there was an attorney such as you. So I
So,
think
yeah,
it's
you can look up
very
mental
needed.
health. Yeah, you can look up mental health. Some law firms will have a mental health group, and sometimes those law firms represent the hospitals. So you're probably not going to get a lot of help there. But sometimes they also represent individuals. I have many wonderful colleagues on Long Island and here in Westchester in the city who do this work, but it is a highly specialized field, and oftentimes I can find, if somebody calls me, I can find them somebody local. And as you can imagine, this conversation about HIPAA is not really state specific. So I help clients all over the country. If they're asking these questions, how do I write an appropriate letter? What can I do? How can I advocate? You're really not bound by saying, oh, you're a New York attorney, because the statute is a federal statute. And very few states have interpreted it differently than the way the federal law. All that could happen under the constitutional standard is the state makes it more narrow, but I don't think most states have done that. So in essence, you're having the same argument. I could change the name at the top of the letter, and I could be producing the same material across all 50 states because the problem is so broadly applied, and so the solution is pretty broadly applied.
Thank you. All right. So just so we know, we have about 15 minutes left. I don't know how many more slides you have, but I want you to
Not
get a
many. That
chance.
many.
Yeah. I mean, this is what blew me away when I heard it, when you presented this. It's like,
Yeah.
what?
It's the
So,
Yeah.
opposite. It's exactly the opposite of what we've experienced and been told all along.
Yep.
Shocking.
Yeah, and if you look at this end of the first page here to help the patient. HIPAA helps you assist your loved one by permitting doctors, nurses, and social workers to share protected health information that's related to the care and assistance you are providing to your loved one. So it's literally taking your life experience and flipping it upside down and saying HIPAA helps you to assist your loved one. But that's not what most of us would say about how HIPAA is used. And it gives this example. If your adult son has been prescribed medication to treat anxiety and you're helping him by providing supervision or housing, the discharge nurse may inform you about the medication if he doesn't object, right? But it says here, if your son is unable to make health decisions independently, the nurse may decide to share this information with you if the nurse determines using professional judgment that it's in your son's best interest, right? So I keep going back to that language because what is the other side of this, right? And I hate to be litigious, but that's what I do for a living. I often will say to a medical facility, there is a much greater likelihood that I am going to sue you if you perform an inappropriate discharge and something terrible happens than that my son is ever going to be able to sue you. A, because my son is incapacitated and couldn't get his way out of this situation if he tried, and B, because that would be an inapplicable use of HIPAA. This HIPAA stat, right? You can look at this, and this is just a snapshot, but 588 breaches reported, it's really, this is all about data breaches, the violations that we see, and I talked about this a lot in the Grace Farms presentation that's on the Silver Hill website, have nothing to do with individual people who have made a report to the Department of Health and Human Services that my HIPAA rights were violated when Dr. Brown shared my discharge plan or my medication dose with my mom, who's taking care of me, paying for my care, and scooping me up out of jail every time I can't get my life together, right? It's not happening that way. And so the medical facility's fear of being sued under the HIPAA rules is just unrealistic. It doesn't happen. And every time I hear that, I say, tell me the last time you were sued, because that's not even what happens. If there is a HIPAA breach, it gets reported to Department of Health and Human Services, they investigate, and if they find it to be credible, they can issue some type of sanction. I have never seen, and I have looked, a lawsuit for a HIPAA breach, unless it's that Cornell Medical Facility, and this is not a real thing, I'm just using an example, forgot to safeguard your information and everybody's medical records got stolen, and then somebody filed a lawsuit for compensation. I have never seen an individual person suing a hospital system for a HIPAA violation. And I
That's
think
what
that,
Dr. Laitman says also, our
yeah,
doctor,
yeah.
who
He and I talk about it all the time.
yeah,
All the time.
it never happens.
It's much more likely, and it's unfortunate to say this, but like most other things, whether it's this, how unhealthy cigarettes were or how unhealthy pesticides are, things that happen, change that happens through litigation because people are held accountable. There will be a time, I would hope in the next near future, where parents who have been negatively impacted by inappropriate or unsafe discharges can pull together to start bringing litigation against hospital systems that don't follow the rules for safe and appropriate discharge. You are much more likely to get sued for negligence or malpractice than you are for a HIPAA violation, because I can't even find anybody being sued for this. So I just think that, we as a community have to be more assertive in saying, I will not be shut down by this inappropriate use of this statute that mostly has to do with tax breaks and computer systems. And I'm going to keep providing you with letter after letter that the HHS has given us telling you you're supposed to use your professional judgment to speak to me. And if you don't want to do that, I'm going to send you a letter and I'm going to tell you that I'm putting you on notice that if you do this, I might sue you. And I think that it's an unfortunate scenario for us as parents, and I don't like to go there as a lawyer, but I do because it's effective. It's effective.
But can people find attorneys to do that though? Because I know just one recent example, a mother I talked to here in Minnesota, and I know a friend of mine several years ago. In both cases, they had really exceptional cases and they couldn't find an attorney to take the case. They didn't want to get involved with dealing with hospitals and
Right.
families with serious mental illnesses.
So what I would say is that the most alike place would be attorneys who handle medical malpractice cases, right? If you can't find a mental health lawyer, the attorneys who most practice in a similar space would be people who deal with other mistakes or bad judgment by doctors, dentists, psychiatrists, psychologists. I see a lot of this in like these pharmacologically based psychiatric places where we just write prescriptions for meds and we have no control over the person. We don't check in, and families who are harmed by that. If you can't find a mental health lawyer, the concept would be that you find someone who's not afraid to threaten litigation. And again, I really think, Mindy, that a lot of this is just putting together a well-written letter. It doesn't have to be on legal letterhead. It always helps if it is, but that says you are not abiding by the standards of safe and appropriate discharge. You're not abiding by, you're inappropriately applying HIPAA. You're inappropriately preventing me from having a conversation about discharge planning. And, it's not a perfect science, but I think even just receiving that kind of letter puts a lot of people back on their heels and they think twice about just sending somebody back out into the world.
I have actually learned to do a lot of this myself, having been doing all this for 25 years. I was
Sure.
stymied by HIPAA myself, but I have made such a issue of myself and kept logs and sent letters. And now it must be in the record there. They just keel over but my son also signs the releases. So I have a leg up on a lot of people. But I just hear so many people that this is ruining their lives. And I think this is a reason why some families get exhausted and drop out. And if their family member somehow goes somewhere else to another city or state, they don't look for them because they can't do anything anyway, and they're exhausted.
I just want to say one quick note on this issue of the patient from the patient perspective. What I find is that when a person, especially if they're involuntarily somewhere, their refusal to sign the ROI is a power play. It's the one thing that they have control over, right? You're in a scenario where you don't want to be there. Maybe someone's forcing medication, they're forcing your participation in treatment or group therapy, whatever it is. And then they come into you with this piece of paper and they say, do you want your mom or your dad who put you in here to talk to us? And it's like, no, I'm going to keep you out because this is my one tool, right? This is my one way of showing you how angry I am, how frustrated I am, how much I don't want your help, I don't want your support. And I think that maybe what's happening, Mindy, with your son and him signing the ROI, I don't know if he always did that, but I find that when we can get behind the scenes and get the information anyway, it takes the sting out of the ROI. The ROI no longer is a tool for the patient to assert themselves, and it just becomes certain information is going to be shared, especially if your discharge plan is to go home, because I have such a hard time with facilities that make discharge plans to send people home and they don't even take the time to confirm that the person is willing to receive the patient because they're afraid, or they have an order of protection, or they have other kids or family members in the home, or they don't have the financial resources to take care of them anymore. Or this assumption that families are just going to keep putting themselves through this is unhealthy for everybody. And it often perpetuates the person's cycle of going through treatment because they think there's no bottom line. It's not a workable scenario for anybody. So I do think that the ROI becomes a different type of sword for the patient. And if they start to get the concept, the treatment providers are going to communicate anyway certain information that's no longer a power play, and they're more likely to just share the information and get out sooner.
That's a good point. And in case ROI is release of information, just in case anybody's scratching their head. You're at your thank you slide. I have a question.
Sure.
Have you done presentations to hospital legal departments informing, and if so, how is this information received? Do you get pushback, or do people go, oh, wow, I never knew that?
So, not shockingly, I've not been invited to do presentations, but I do have very frequent conversations with what most hospitals call it risk management. That's the department that would handle, they don't call it legal, they call it risk management. And so I will often have these conversations one-on-one, and maybe we'll establish some type of rapport, especially the facilities here in Westchester I work with all the time. The lawyers know when I'm calling, they know my email address. The place I've had the most impact is with the court system. So I have been invited on a number of occasions to speak to the state judges, and even spoke recently at a federal judges roundtable. And those conversations are often really enlightening because you realize just how little most judges really understand about mental health. It's not a subject that's covered. Judges actually go to school. They don't cover this in judges school. They cover a lot of other topics. Guardianship has recently gotten a lot more attention at judge school, but the mental health piece in New York, the Article 9 piece, very few judges really know about it. So I try to give an opportunity for them to understand how we can more efficiently use the laws that we already have, including the provisions in the guardianship law that would give us the end around HIPAA, like you have, Randy, where if you give certain powers in the order and judgment, which is the decision, that perhaps in certain limited cases, you can have access to protected information, even if the person refuses to consent. And so, especially in cases where the as you can imagine, in cases where the origin of the disability is not mental health, but is cognitive impairment or developmental disability, we never have a problem there, right? I've never had a client who has guardianship over their autistic son be denied medical information. Just doesn't happen.
Yeah. Yeah.
But it just happens in the other world, unfortunately.
It's a whole, and of course, this brings up a whole other topic for another show, which is because we have talked about how the um, the lack of required education for school counselors and guidance counselors, and sometimes even social workers who are serious mental illness is an elective. Not everywhere, but in Canada and in America, like it's not required that they learn about it.
Right.
I did not know there was such a thing as judge school, and now I do. And I wonder if they know. I mean, I'm unfortunately living in one of the two states that doesn't have AOT yet, but I don't know if judges know how to enforce it or how to use it.
Right.
Do they learn about AOT? Do they learn about that? You said they don't learn about conservatorship or guardianship. So that's another thing in the system, another hole in the system to think about and talk about. Laura, is there any final tips, final words, final resources that you want to share with our families?
Yeah, so I would just say persistence is the key. And I know that persistence can be in short supply when you feel like you are cycling through the same place over and over again. But the family members that, or whether they do it themselves or they have an advocate doing it for them, and it doesn't have to be a lawyer. There are lots of other types of advocates who could do this kind of work. But, people who are consistent in making their demands clear and people who are consistent in saying, do not create a discharge plan that involves me or my life without consulting with me. Don't make assumptions. Putting people on notice, using that language. I'm putting you on notice, which has a legal significance, right? I'm putting you on notice that this is not a safe or appropriate discharge for the following reasons, right? I think that it's a matter of spending some time on the HHS website, which is super important. NAMI also has a ton of resources on HIPAA and your rights in a hospital setting. Of course, always remember you can provide as much information as possible. I have all of my clients, many of you probably already do this, but I find it incredibly helpful. Create a packet of a timeline of your child's hospitalizations, your loved one's hospitalizations, the most recent medical records. If you ever get access, get all the medical records from every hospitalization. When you have access, if the ROI is signed, make sure you get all the records from that hospitalization. And you can create a pretty big packet of information. And then when the person gets admitted, you say, here's my 150 pages of all of what's happened to them over the last 2 years. And it can be very powerful for, as you can imagine, a medical community that wants to make one phone call. And if they don't get the answer, they just hang up the phone and the chart stays empty. Well, especially if your child's moving from state to state or facility to facility, the more condensed you have, and I do that work with my clients. I help them compile it. We put together a packet that's always at the ready. It's a PDF. I can shoot it off in 15 minutes. Here's the most recent history. Here's the most recent hospitalization. Here was the medication that worked the best, in an attempt to just show the hospital that you're a force to be reckoned with and you're not going away. And I know that that can be exhausting, but I sense that most parents are going to do something anyway, and you might as well do something that's effective.
And I will just say, having done it for 25 years, I don't do that anymore. I have a one-page summary, and it's dated. It's a summary that they will read, and then I have documentation can be provided or something like that. But that serves notice as well. If you get past the point where it's physically impossible to carry all that stuff.
Right. Yep.
Thank you. And one more quick question.
Sure.
A role play. We're not getting to discharge. You've just found out that your son was sent to the hospital by the police or whatever. And you call up and you say, hello, is my son blah, blah, blah here? And they go, can't tell you anything, HIPAA. What would a good response at that moment of admission be?
So what I would say is, what is your name and title? Give me your phone number. And can you also give me the hospital, the risk management office or the legal office because I have a letter I want to submit. If you had your letter ready, you would say, I would like your email address, because remember, they can never prevent you from providing information. They can say, can't tell you if he's here. We usually know the person is there. I want to send you information in the event he's here, which we know he is. We didn't talk about this, but if you have a healthcare proxy or other document that they had already signed, that would be an appropriate time to send that as well. Psychiatric Advance Directive, which many more states are recognizing as a really important tool, which is another conversation, could also be provided at that time. But I would pretend like the person didn't give you an amorphous answer. I would make it as if they were there and say, I need this, this, and this. You don't just hang up the phone and say, oh, I'm so sorry, or you just get super assertive and say that I need an email where I can send information. I need the name of the legal department or the phone number. And even they should be able to give you a treating physician, because that's not HIPAA protected. There's no reading of HIPAA that says that's protected. And then you can start sending over these letters or your HHS summaries or whatever it is. And once they start seeing that you're informed, they're much less likely to give you the brush off and tell you to go away.
I wish I had that information the first time Jim was hospitalized. That is what Brandy gave as the scenario. Happened to me, and I didn't know what to do, and I did none of that. I was in the legislature at the time, though, so I did run back to the revisor's office and get some legislation to try to work on this.
Right.
And they told me, actually, both physical and mental illnesses are the same, so there was nothing I could do to make them the same. They already were. We all learn as we go along. So I'm so glad people starting out can see this program.
Yeah. Well, Laura, thank you. I mean, and
my pleasure.
This information, I think, is going to help a lot of families all around the country. And the Health and Human Services website, just Google Health and Human Services HIPAA and those documents. And she said NAMI has a lot of those documents as well.
Sure.
And on the Silver Hill website, there is a video of you doing a presentation called Families in a Double Bind, the Need for Legal Advice in Navigating the Psychiatric Health System. So it's this HIPAA information and more, and that is just available for anybody to view.
Yes.
So, very much I so appreciate all you do and the way you presented it. And thank you so much on behalf of our listeners.
Thank you. My pleasure. Thank you for having me. And, if anyone needs further information, you can always give them my contact, my email. I think we're all in this together in different ways. And so connecting resources is probably the most important thing that I do on a daily basis. So however I can help, I'm happy to do that.
Thank you so much for tuning into this episode of Schizophrenia, 3 Moms in the Trenches. You can help out the podcast and help others by sharing the podcast and by subscribing wherever you get your podcasts and or on YouTube. And remember, you can reach us at mindygreiling.com, randyk.com, or miriam-feldman.com.